Hi, I'm Shashank Bhargava, and you're listening to Three Things, the Indian Express news show. In this episode, we talk about the legacy of the former Punjab Chief Minister Parkash Singh Badal, who passed away earlier this week. We also talk about Bihar amending its jail manuals and releasing 27 people, including a politician, convicted of heinous crimes. But first, we talk about marriage equality. For the past 1 week, a 5-judge bench of the Supreme Court, headed by the Chief Justice of India D.Y. Chandrachud, has been hearing a batch of petitions which are seeking legal recognition of same-sex marriage. In fact, yesterday, the petitioners gave their final arguments about why this should be the case. And the court will now be hearing arguments from the centre regarding this issue. In this segment, we are joined by Indian Express's Apurva Vishwanath to talk about the case so far. So, Apurva, begin by telling us what exactly these batch of petitions are seeking.
So the Supreme Court is right now hearing a batch of petitions seeking same-sex marriage. It might not be entirely correct to say only same-sex marriage. This is a case about marriage equality really, because some of these petitioners are also trans people. It's not just same-sex marriages, but broadly equality in marriages which heterosexual couples have, the same being extended to everybody else.
And Apurva, these petitions are being heard after the 2018 verdict of the Supreme Court, where the Section 377 was struck down. Could you refresh the memory of our listeners and talk about what that did for the LGBT community?
Right. So the 2018 judgment, Navtej Johar versus Union of India, is really a watershed moment when it comes to the LGBTQ rights in India. So the Supreme Court essentially struck down Section 377 of the Indian Penal Code to the extent that it criminalized homosexuality. But what the court also did in that judgment was essentially said that the queer community are equal citizens as anyone else, and underlined that there cannot be any discrimination based in law, which is rooted in sexual orientation and gender. So this judgment really opened a window for seeking recognition of more rights, and that's how you have the petition today. But it's not just the 2018 Navtej ruling. If you look at how the law has traveled in the last few years, it starts really from the Nalsa judgment, which was in 2013, where the court recognized transgenders as the third gender and said that they have equal constitutional rights under the Constitution. So this judgment, where the court really upheld right of a transgender person to decide their self-identified gender, also opened the doors for, more rights to be recognized in law in the future. Then, of course, you have the 2017 verdict, which recognized right to privacy as a fundamental right. Then there have been a bunch of smaller bench judgments, which is 2 and 3, not really on queer rights, but recognizing marriage as a fundamental right, recognizing the right to choose your partner, identifying that right within the core zone of privacy, which is a part of our right to life and personal liberty, right? So a bunch of these rulings have essentially led to the present constitutional challenge, where all the rights that exist with heterosexual couples should be extended to others as well.
And Apurva, for many in the country, the idea of a marriage that does not involve a heterosexual couple, a cis man and a cis woman, is considered a bit of a radical idea. But is it also a radical idea as far as the law is concerned?
So, the last 1 week, the petitioners have been arguing their case, right? So there is one stem that really flows through all the arguments, that is it that alien to, say, even the Indian law and the Indian culture and society in the larger context, right? There have been a change in course on the law in so many aspects. For example, an intercaste marriage in the 18th century would be radical and unheard of as much as a same-sex marriage is today, right? Or an inter-religion marriage for that matter. And to think that till 2013, the transgender community did not have equal rights, or till 2018 when 377 was struck down, sexual orientation in India was criminalized, right? So with time, the rights, how we recognize them, and their expansion obviously changes. So that's something that the petitioners are saying now. But is it an entirely radical, idea? Some of the arguments, when you see that, it's not. The law really acknowledges that these situations can happen. For example, if there is a heterosexual couple at the time of their marriage, and subsequently one of them identifies as a different gender, and now under the Transgender Act, you have the right to decide for yourself. You go to the state and get a certificate saying that your gender is now different. So, but does that mean the marriage automatically is nullified? No, it's not. Which means that the law acknowledges that there is room for all sorts of, marriages, all sorts of scenarios. Ultimately, issues like marriage, issues like companionship, these are very private spaces which have been governed by personal law, which have been governed by religion. So you're right. In that sense, the change will be very slow and it would seem like a radical idea. But that is essentially the petitioner's claim, that this is now time for change.
And Apurva, what have the petitioners said about why they are fighting for the right to be married? I mean, one argument, of course, is that everyone should have the right to do so. But could you talk about the benefits two people in India can enjoy after being married?
So this is really an equality question before the law. A queer person is as much an equal citizen under the Constitution. So what stops the law from preventing them to exercise the same rights that a heterosexual couple does? So that's really the question, legal question, big legal question before the court. It's an anti-discrimination case if you frame it that way, right? But apart from that, of course, it's not that simple. It's not just let's extend the same rights, because marriage is way more than that. And that's the second answer to the question, which senior advocate Menaka Guruswamy really, said in court. What Dr. Guruswamy argued was that marriage in itself is a civil right, sure, but marriage is also essentially a bouquet of other rights, right? It could be from legitimately introducing your spouse in the society, which really comes from the right to dignity that we exercise every day, right? To getting access to other things, like she mentioned, pension, gratuity, the fact that you can have a bank account together, the fact that you can pass over your property to your spouse. So inheritance laws are essentially, family laws, right? So, and the right to adopt, right to have children, and the right to decide for yourself. So these are the essential aspects why, this case is happening right now and why they're seeking equality in marriage.
Okay, so what the petitioners are arguing for is equality. And what they're saying is that the current legal framework does have room for that. What are the other arguments that have been presented in the favor of this?
So one of the things that the center said in its affidavit when this case was brought about is that the state has a legitimate interest in regulating the institution of marriage, right? Which means to a certain extent, the state can encroach upon your fundamental rights because they have an interest in regulating this space of marriage itself. So here is where maybe the benefits really also flow to the heterosexual couples. That some of the petitioners' arguments are that the conditions under the Special Marriage Act, you have to remove those fetters in law. Basically give complete autonomy to people who want to marry, who can choose for themselves to marry. For example, the Special Marriage Act has a condition for notice, which is a 30-day notice period, where when you go and declare your intent to marry, the notice will be put up in the sub-registrar's office, and sometimes they even make inquiries with your natal families and invite objections. So some of the things that the petitioners are challenging is the extent of this so-called legitimate state interest. Can the state really interfere in your marriage? Whether that is interfaith couples, intercaste couples, or for that matter, queer couples, right? So pushing back on this state interest is also one of the themes of the petitions that's being heard in the Supreme Court right now.
Okay, so on one side are these petitioners and on the other is the center. And although at the time we are recording, the centre has yet to begin its arguments, but do we know about how it's going to argue the case?
So, Solicitor General Tushar Mehta is expected to begin his arguments in the second half of Wednesday. But the fundamental point that the centre has already made in its affidavits is that this is not a fit case for the court to decide. That something that touches upon the social fabric of our society is the domain of Parliament, and the Parliament should debate this issue. So the government is not in favor of allowing queer marriage through a court diktat, but it wants to debate this issue in Parliament. So that's the maintainability aspect of it. That's the preliminary objection that the centre has raised.
And by maintainability, the centre is saying that these petitions should not be heard in the first place.
Yes. Maintainability would be the preliminary argument, whether the court can even hear these issues or not. But from what we've understood so far is that the Supreme Court has made up its mind and indicated to the Solicitor General that it intends to hear the issue fully. And also in the final judgment, we expect them to rule on maintainability as well. But from the observations of the judges, it is clear that they are not in favor of the government's argument on maintainability. But in the affidavits we've seen so far that the centre also has said that gay marriage is really an urban elitist concept and it only affects a few people and the court need not go into it at this stage. So on Wednesday, in an observation that Chief Justice D.Y. Chandrachud made, he said that this elitist argument is really just prejudicial and it will not have any bearing on how the court will rule on this issue. So you've seen glimpses of what the centre thinks on this, but the substantive arguments we'll only understand when the Solicitor General opens his submissions.
Now, last week, Indian Express's Premankur Biswas had spoken to one of the petitioners in the case, Kajal, who is about 28 years old and lives with her partner Bhavna in a small town in rural India. And Kajal told him that there are actually a lot of queer people in rural India and that legalizing same-sex marriage will give such people a lot of confidence.
सर सबसे पहले ये होगा कि जरूरी नहीं है ये शहरों में है, ये गांव में भी है, बल्कि कुछ लोग ऐसे हैं जो अभी बताने में उन्हें ये हो रहा है कि पता नहीं, लोग सामने नहीं आ रहे इस रीजन से. अगर सेम सेक्स मैरिज एक्ट आता है तो सबसे पहले तो कॉन्फिडेंस आएगा तो लोग सामने आएंगे और उन्हें पता, क्योंकि आज से 2 साल पहले या 3 साल पहले जब भी 377 नहीं भी हटा था तब भी मेरे जैसे लोग कभी सोच के बैठते थे कि हाँ ऐसा हो सकता है क्या, हम अपनी मर्जी से जिंदगी अपनी चूज कर सकते हैं क्या, क्योंकि घर वालों ने तो अपनी मर्जी से शादी कर देनी है, बाद में तो एक दिन काटने वाली बात होती है. तो ऐसे और भी बहुत लोग हैं, शहरों में भी हैं, गाँव में भी हैं, जो इस चीज का बस वेट ही कर रहे हैं कि सेम सेक्स मैरिज आएगा, कॉन्फिडेंस आएगा, राइट्स मिलेंगे तो और भी ज्यादा जो जिन लोगों से हम छुपाते हैं या जिनसे बताने में अभी ये होता है हमें कि पता नहीं हम इन्हें बताएंगे तो क्या, कुछ लोग तो मजाक भी उड़ाते हैं ऑब्वियस, तो ये चीजें नहीं होंगी फिर.
And next we talk about Sardar Parkash Singh Badal, the 5-time Chief Minister of Punjab and who is widely considered the architect of the Shiromani Akali Dal Party, passed away on Tuesday at the age of 95. Badal's career in politics started when he was elected as a sarpanch at the age of 20. He rose through the ranks and eventually became the youngest chief minister of the country at the age of 43. Now, his political career spanned over 7 decades, and through it, he is said to have changed the political landscape in Punjab. To understand how he did that, Indian Express's resident editor from Punjab, Manraj Grewal Sharma, joins us. Here's my colleague Rahel Philipose in conversation with her.
So, Manraj, tell us how Parkash Singh Badal became such a central figure in the politics of Punjab.
So, the history of Badal in Punjab is almost like the history of Punjab itself, because he happened to join politics when India became independent. So he became the youngest Sarpanch at 20 in 1947. And from there on, he became an MLA, the youngest chief minister of the country, and then he became the oldest chief minister as well. So there's this huge, he saw everything, right from the Punjabi Suba movement to the militancy the Green Revolution, and the return to peace, and the present day. So his career, which also shows that he was a very innate politician. He was essentially a people's politician. So he wasn't like a professional politician. He believed that, to be in politics is to do service. He used to say, Raj nahi seva. And then he was also very canny, very shrewd. So besides being very people-centric in his focus, he also knew how to play his cards well. So Akali Dal used to be a very splintered party. It kept getting splintered. It happened partly during the Punjabi Suba movement, then after during militancy. So Badal emerged as the tallest leader of Akali Dal. And it was in 1997, after militancy, that he became the president of the Shiromani Akali Dal, Badal. So now when we look at Akali Dal, which is it is the oldest regional party. It's more than 100 years old now. So when you mention Akali Dal, when you think of Akali Dal, you think of Badal. He's such a towering figure. And of course, it helps that he was a chief minister 5 times, beginning in 1970. And it was for the first time that any party in Punjab came to power for 2 consecutive terms, and that happened under his leadership. From 2007 to 2017, Akali Dal, BJP combined, had 2 consecutive terms in Punjab.
Right, and you mentioned the Akali Dal is the oldest regional party in the country, and Badal's widely considered its main architect. Can you tell us how he transformed the Shiromani Akali Dal?
See, Akali Dal started as a Panthik party, as basically a Sikh party which would look after the aspirations of the Sikh people. This happened in 1920. So it was established on 14th December 1920. So Badal, as time went by, Badal changed it to make it more inclusive. So from being only a Panthik party for the Sikhs, he made it a party for the Punjabis. And although all along he had been having post-poll alliances with Jan Sangh, which is essentially the precursor to BJP, but in 1997, he formed a coalition with the BJP. In fact, Badal, Akali Dal was the first party to lend its support to the first BJP government at the centre in 1997. So since this was a period shortly after the Punjab was coming out of militancy, this coalition was very important because it was a guarantor of communal peace. And interestingly, even in 1970, when Badal came to power for the very first time, he said, I will work for communal harmony in the state. I will see that there is no schism between the 2 communities. So that is kind of one of his hallmarks, was his secular nature of his governance.
Right, but while he spoke about secularism and Hindu security, his own beliefs were challenged time and time again during his career, right? How would you describe his political ideology?
Yeah, so Badal, for one, really believed in devolution of powers. He believed in more powers to the state. He felt that, when it came to little matters like roads, etc., we should be the one to decide the industrial policy, the local, and let the major policy, say the foreign policy, should be the central government subject. But the states essentially need more powers in case they want to progress. So, but while believing that, he was very clear that he did not want to separate from India. So he never, even though there were members within his party who raised the demand for a separate state, he would always rebuff them. So, and even during Operation Blue Star, though he blamed Congress, and in fact he was even jailed for sedition, because after the Blue Star, it was alleged that he gave a call for mutiny to the Sikh troops. So, but essentially he remained very true to India, who said, okay, we need more powers, but Punjab has a role to play within India. And he was very clear about it. So that way he walked a very thin line, and he was undeterred even during militancy, when he was basically with his back to the wall because the radical leaders were on the front.
And he was no stranger to controversy, right? In fact, there were incidents of sacrilege, and the Kotkapura police firing case that haunted him until his very last day.
Yeah, the day he died, that is yesterday, for the Punjab police, the SIT presented a supplementary charge sheet against him. So this was in 2015 when Guru Granth Sahib, the holy book of the Sikhs, was desecrated. And subsequently there were protests, police opened fire at Behbal Kala, which is right across Bargadi, where the torn pages of Guru Granth Sahib were found, and 2 people were killed. Although while he had 2 more years to go in power from 2015 to 17, they set up an SIT, etc. They never came to a conclusion about who was behind all these sacrilege incidents, because there was not one. After that, there were many, many such incidents. And that really haunted him to the very end, because people thought that he had let the main culprits go scot-free. And the latest SIT charge sheet, it accuses of him of being part of this conspiracy, that it aided this conspiracy, that they wanted to distract people's attention from the incident of sacrilege, which is why the police opened fire. So it's very interesting, because last month, after the first charge sheet was filed against him, he wrote an open letter to Punjabis basically, saying that, this is very unfortunate what happened in 2015, and I'm very sorry about it, but I have lived my life trying my best to work for the peace and harmony of Punjab and for the development of all Punjabis.
And Manraj, if we were to look at politics in Punjab today, is Badal's influence evident?
Yeah, he was, AAP came to power promising free electricity to everyone. And in Punjab politics, it was Badal who introduced this regime of SOPs, as we call it, of subsidies. He believed that the poor have to be protected, that no matter how the way you slice your economy, you have to make sure that they get the leg up they require. So it was in 1997 when he came to power for the 3rd time that he introduced free power for marginal farmers with land holding of less than 7 acres. And then subsequently, he also felt that the Dalits were very marginalized in Punjab. So he introduced an Atta Dal scheme for them. So giving them free ration every month. They had special cards made for the BPL. So if you look at it, that all of that happened in early 2000 or in 1997. And now the present day AAP government, for instance, it promised a stipend of 1,000 a month to women. Every women in the state, although that they haven't really fulfilled that promise. But the fact remains that the logic, the rationale that you have to give a leg up you have to help your constituency, that is essentially Badal's philosophy.
And next we talk about Bihar. On Monday, 27 people were released from various Bihar jails after serving 14 years in connection with murders and other heinous crimes. And among these 27 people was also the former Bihar MP Anand Mohan, who was convicted in the 1994 murder of the then Gopalganj district magistrate G. Krishnaya. Now, what is important to note is that these people were released after the state government amended the Bihar police jail manuals. And according to this amendment, after spending 14 years in jail, your sentence becomes open to be reviewed, and you become eligible to be released. And this is what happened to these 27 people. But this was not the case earlier.
Before this amendment, if a convict in a heinous crime completes 14 years, that would not be taken as life sentence as it is made out to be. That if somebody serves 14 years, it is called life sentence. It is not life sentence in that case. In that case, he has to complete 20 years, and that will be also subject to review.
That's Indian Express's Santosh Singh, who reports on Bihar for the paper. And he spoke to us about this amendment. And he says that although the Bihar government is saying that this was not done to benefit any one particular individual, it has raised concerns because of Anand Mohan being released, a politician who still has strong ties within the Rajput community. For example, the government says that many of those who got released are over 60 years of age, and their poor health condition was one reason for amending the manual. But when questioned about the younger people who were released, the government said that it wanted them to have a second chance in life. Santosh says that considering how much Chief Minister Nitish Kumar has spoken about good governance in the past, this change does not align with that, and the motivations appear political.
And I have been covering for Bihar for all these years. I don't remember the state government having considered any such waiver in last, say, 17, 18 years. This is the first time I would say the governance is scaled down, even though government is well within rights to amend it. It's their administrative prerogative. They can do it. But if you ask me as an independent observer, I would say this is not the same Nitish Kumar we have seen in 2007. And the motivation which motivated this amendment is political, purely political. That is, I think, the darker side of it. That is something raises concern. This government, which had, as I earlier said, taken high moral ground on governance, this government which used to talk about speedy trial, speedy conviction, so I would say it's a scale down. It's not a very happy sign in that regard.
Now, talking about Anand Mohan, Santosh says that he has been a trailblazer of sorts, and his rise has been parallel to the former Chief Minister Lalu Prasad Yadav.
He was very much part of the Janata Dal government in 1990. But soon, say in 2 years down the line, he was not getting along well with Lalu Prasad. He fell out with him, and then he formed a small organization. And finally, in 1993, he formed his own party called Bihar's People's Party. And Anand Mohan was instantly taken as hero of upper caste. He would go to any place, say Patna's Gandhi Maidan, or travel other parts of the country and get a very wide audience who did not support reservation.
And this is the reason Santosh says that he was considered a strong anti-Lalu voice. And so later Anand went on to gain the support of the Rajput voter base in the state, a community he belongs to. But in 2007, like we mentioned earlier, he was convicted in the murder of G. Krishnaiah. And it is in this case that he has now been released.
He has already completed 14 years in prison, and by that logic, after change of tweaking of the rules or amendment in the rules, he qualified for the waiver. And that's why it paved the way for his release. He is already on parole, and he just attended ring ceremony of his MLA son Chetan Anand, and Nitish Kumar also attended that function in Patna. He's on parole, and quite possible he might not have to go back to jail. And from parole itself, he might have to do some paperwork and he can get free.
But his release, of course, has raised a lot of questions. Santosh says that many fear that this has been done keeping in mind the general elections next year, and so that the current government can gain the support of Anand's voter base, especially those belonging to the upper castes.
So everybody is trying to consolidate and poach into each other's constituency, at least in region-wise. And since there is no Pen Bihar Rajput leader, and Anand Mohan is only prominent Rajput leader, so the political importance of this person, I think this has forced the tweak in the law.
And Santosh says that Anand Mohan's influence in the Rajput community is also the reason why the opposition BJP is silent on this issue.
You know, upper caste Rajput is also the prime constituency of Bharatiya Janata Party. So they would not do anything that could antagonize, displease their constituency. So their reaction is very guarded. They are not targeting the government for this waiver. It's only some Dalit organization, some IPS officer like Amitabh Kumar Das, who have been protesting. Even former UP Chief Minister Mayawati criticized this. So, but if you talk of Bihar's political party, I don't think there is much resentment to this.
You were listening to Three Things by The Indian Express. Today's show was edited and mixed by Abhishek Kumar and produced by Rahel Philipose, Utsa, Sarmin, Anwiti Singh, who had originally spoken to Santosh for the Bihar story. and me, Shashank Bhargava. If you like the show, then do subscribe to us wherever you get your podcasts. You can also recommend the show to someone you think will like it. Share it with a friend or someone in your family. It's the best way for people to get to know about us. You can also tweet us at Express Audio and write to us at podcast@indianexpress.com.